Deborah, I have another tough case that you don't know anything about.
So I should sit back down.
Mr. Weller's sleeping through most of this, but we're gonna wake him up here to do our hearing.
I wondered.
And it's got a lot of money involved and he's not real with it and he's late. And I'd ask if you would stay. I apologize.
Anything to make this.
It's another no lunch Monday. Why don't you go ahead and turn it back on for you now? I would have considered even maybe bumping this, but the complainant is here and he's been waiting for a long time. So we'll address it.
Buckle up, guys. Today we are stepping inside Judge Middleton's courtroom where a routine hearing quickly turns into something far more layered. What starts as another docket call becomes a tense setup involving serious money, prior delays, and a defendant who doesn't seem fully engaged. The judge makes it clear this case has already dragged on, and the victim has waited long enough. From the very beginning, you can feel that patience in this courtroom is running thin.
This is file 23738 FY, People versus Timothy John Weller. Mr. Weller was charged with a felony computer crime. And as I mentioned, we're returning to the bad old days of multiple remands. This matter was bound over to the circuit court on a felony charge. A large amount of money was taken, $8,000, and it got remanded back to our court for a plea and sentencing. Well, I'm not sure I'm ready to do a plea and sentence, but I would be ready to do a plea. They're remanding these matters back for plea and sentence, but by the nature of the fact that they were a felony and came back as a misdemeanor, they're complicated. I don't know what happened. This case got bound over. There were several status conferences. It was going to be set for trial and it got remanded. And so the remand plea, Mr. Weller, would be to a misdemeanor charge of larceny over $200, but less than $1,000. The original charge was an allegation that you stole $8,000 from a Mr. Gregory White.
Here, the full weight of the situation becomes clear. The judge outlines the original felony charges, computer crime, grand larceny, and even habitual offender status that could have meant life in prison. Then comes the twist. The case was remanded and reduced to a misdemeanor. As an observer, the shift feels dramatic. The stakes were once enormous, and now the court must process how an $8,000 theft case landed back in district court with far lighter consequences.
That larceny charge is a just plain old grand larceny, punishable by up to 5 years imprisonment and a fine of up to $10,000. The computer part of it is a allegation that used a computer program, computer system, or computer network to steal more than 1,000, but less than 20,000. That's punishable by up to 7 years imprisonment and a fine of up to $5,000. You're also charged as a habitual felon as a fourth felony offense, making this punishable by up to life in prison. So the matter got bound over to circuit court. The can got kicked down the road a little ways, and then it got remanded back here for a plea to a misdemeanor charge of larceny more than $200, but less than $1,000. Mr. Weller, that's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000 or 3 times the amount of the money taken. In this case, it's alleged to be $8,000. So the prosecutor, and let me confirm this, Ms. Davis, has offered to dismiss the felonies and the supplemental for a plea to larceny over $200. And I understand you inherited this, but thank you for being here.
Quickly looking through the notes, it appears that yes, Prosecutor Marvin had made that offer larceny 200 to 1,000, and that the restitution was $8,000 joint and several between Weller and Sproul.
This segment breaks down the plea deal in detail. The prosecution confirms that the felonies will be dismissed in exchange for a misdemeanor plea, but restitution of $8,000 remains on the table. The judge's tone suggests caution rather than celebration. Even though the charge is reduced, the financial harm is real. The courtroom dynamic shows that while the legal classification changed, the impact on the victim certainly did not.
She is set for sentencing later this month with Judge Pattison. All right, Mr. Weller, the allegation is that you're going to be ordered to pay $8,000 restitution, joint and several, with Heather Sproul, one of your co-defendants here. Do you understand?
Yes, sir.
Could you take your hand away from me? Are you going to plead to that misdemeanor charge of larceny over 200 but less than 1,000?
Yes, sir.
Mr. Bush, you confirm that's the plea
Yes,
offer?
it'll be more on an aiding and abetting factual basis, but we have previously discussed that. And this is not a spur of the moment decision today.
All right. Mr. Weller, do you understand that if you do plead to that charge, you'll be giving up your right to have a trial in front of a judge or jury?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Bush is here with you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand yourself and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent if and until the state was able to prove your guilt beyond a reasonable doubt. You understand?
Yes, sir.
Did you somehow induce the complainant here, Mr. White, to give you $8,000?
No, sir.
Well, tell me what happened.
I was solicited by Miss Heather Sproul to go open an account in my name, and what she did, she stole Mr. Gregory White's phone and transferred the money from his phone into my account. Somehow she got a hold of my account information and transferred the money into my account.
Now the judge methodically walks the defendant through his constitutional rights: trial by jury, presumption of innocence, the right to remain silent. It's a procedural moment, but a powerful one. This is where the system ensures the plea is voluntary and informed. The gravity of giving up those rights hangs in the air. It's not dramatic in volume, but it's significant in consequence.
All right, that was $8,000. All right, well, and then you took $4,000 of that dollars and blew it at the casino?
No, you did not. The only thing I got out of that was like $500. Your Honor.
Well, you must have known there was some nefarious purpose for you to just blankly open an account.
She told me that, Your Honor, not to cut you off, but she told me that she inherited the money from her uncle. So I went and opened the account, and she went and, like I said, stole Mr. White's phone and transferred it. That's how she got his information. That's
All
from
right,
that
but
phone.
then you withdrew $8,000 from the Omni
That's
Bank.
because I believed her that she inherited that money, Your Honor. If I had known that, like I told Mr. Gregory White, if I had known it was his money, I would never have done it in the first place.
Timothy stated Heather gave you $3,600 and she kept the rest.
No, that's not true.
Now that's what the police say.
He must have misunderstood what I was trying to tell him.
All right, well, you
May
didn't
I
just,
inquire on it?
yes.
And Mr. We've talked about this, and in retrospect, you realized that it was kind of a hinky thing that
Yeah,
that money was there for just a couple hours and you were paid either their theory, multiple thousands or $500.
I still can't take responsibility for it, Your Honor. What?
All right, so you knew this wasn't all on the up and up.
Right, Your Honor.
And he's open to his share of restitution. I suggest to the court that he wasn't as sophisticated as the other individual to put this together.
He's also not as dumb as he presents here. He knows more than,
And I'm willing to pay him back whatever the court wants me to pay him back.
This is where the narrative shifts from procedure to credibility. The defendant claims the money appeared in his account without ill intent, blaming the co-defendant and an alleged inheritance story. The judge listens, but skepticism is visible. The explanation feels strained. As a third-party observer, this is the turning point where the story begins to unravel under basic scrutiny.
Her name is Sproul. Let me see, because she's set for sentencing on a certain date. Let's see if we can line these up, save the complainant. Well, that can't be right. Set for sentencing on September 5th. So let's see how I look for September 5th at 10:30. It's next Tuesday. I can do it. All right, I'll accept your plea at 10:30. I'm not sure how we're gonna do this. Let's say it. Mr. Wilson?
Yes, Your Honor, please the court, I provided transportation for Mr. White because quite frankly, he has none. And I will not be able to do so during the month of September.
Well, I can, the other case is already set for September 5th. Mr. White, I can give you a bus pass to get here and back on September 5th. So I'll give you a round trip bus passes for that morning. But you're gonna need to be here for Ms. Sproul anyway. So here's 2 round trip bus passes for you to get here on September 5th. Courtesy of generous people that watch this channel.
The casino detail lands hard. According to police reports, thousands were withdrawn and lost gambling. The defendant disputes parts of it, but the larger issue remains. He knew something was off. The judge presses him directly. This exchange sharpens the tension because it highlights awareness. Whether he took $500 or $3,600, the underlying acknowledgement of wrongdoing becomes difficult to avoid.
What time are?
I'm gonna set this for 11. The other one's at 10:30. Now, you called this morning, you were out of state or you had to be somewhere. How'd you get here today?
Cousin, my cousin brought me all the way back.
All right, how'd you get here to the courthouse?
My cousin drove up here, drove me here.
Where's he?
He took off. Yeah, I'm supposed to let him know I'm supposed to get a hold of him because he has no phone now.
Hi, could you guys check and see if Mr. Weller drove here today? Yes, thanks. Bye. You've got a terrible driving record.
Yeah, they'll see me getting, Your Honor, I have to cut you off again, but they'll see me getting out of a passenger seat of a maroon or burgundy colored Dodge
All right.
and passenger side.
Now, in the
It was in this parking
report,
lot out
we're
here.
talking about driving. The other thing I need to confirm, I don't know whether that interview was recorded. According to the affidavit of probable cause, she gave you $3,600, which you took to Firekeepers and lost, except for $23. Plus, you were driving all over the place.
I learned my lesson from
I
that,
made
Your
a
Honor.
traffic stop bearing a Michigan temporary plate, made contact with Timothy Weller in the driver's seat. I don't know what I'd do to keep you from driving. So there's a dispute about how much money you took. You don't have 2 nickels to rub together. I'm not very encouraged about this man getting his $8,000 back. But you agree that the restitution will be 8,000 joint and several with Miss
I'm willing,
Sproul?
like I said, I'm willing to make this right with him. I mean, I feel bad about it, and I'm willing to do whatever it takes to make it right.
In contrast to the tension, this moment shows judicial compassion. The victim struggles with transportation, and the judge personally arranges bus passes to ensure he can attend sentencing. It's a reminder that beyond legal arguments, real people are affected. The court demonstrates balance, firm with the defendant, supportive of the victim. It subtly reinforces who truly bears the burden of this case.
And I do want to I have not looked at this carefully, obviously, so in just going over the bank statement that I pulled up, there may be some withdrawal fees and that sort of thing, so
Okay,
I guess I would like to leave that restitution somewhat open. I mean, it's expected it's going to be around the $8,000, but there may be some fees. I want to get that cleared up so that the victim is made right. But I also have concerns about Mr. Weller's ability to be here himself on Tuesday. And if we have the victim coming back and the other co-defendant, I want to make sure that he is going to be here as well. So I guess I'll leave that to the court's discretion as far as that goes.
I'm willing to come back.
all right, yes, your bond's canceled.
Attention shifts to another concern: the defendant's driving and credibility. After claiming someone brought him to court, verification suggests he may have driven himself despite a troubling record. The judge investigates on the spot. This isn't just about transportation, it's about trust. Each inconsistency chips away at the defendant's reliability in the eyes of the court.
They'll bring you back. And we'll deal with it. That's next Tuesday, which is 8 days. Stealing $8,000 from this guy certainly develops at least 8 days. Plus you keep driving a damn car.
No, I think he's been in jail for upwards of 45 days in this case.
Yeah, he bonded out. I'm not sure how. And I set the bond at the amount that was stolen. I think it got reduced when it was remanded. And I don't like these remands, and there's not much I can do about it, but they come in, they're always difficult to deal with. Yes, your bond's canceled. You're no longer presumed to be not guilty. I will see you next Tuesday at 11 o'clock.
Thank you, Your Honor.
What am I going to deal for?
Your bond's canceled.
Why is my bond being canceled?
Here, the focus returns to restitution. The judge openly questions how someone with limited resources plans to repay $8,000. There's doubt about feasibility and accountability. The prosecution raises concerns about ensuring his appearance at the next hearing. The mood tightens again. It's no longer just about admitting guilt. It's about whether the victim will ever be made whole.
Because you just pled guilty to helping somebody steal $8,000 from this man.
Yeah.
Plus you showed up late and slept through most of the earlier proceedings. I'm not sure what's going on with you, but I hope you're in a better state of mind when I see you next Tuesday morning. All right, you're free to go.
Thank you, Your Honor.
Why am I being arrested for? I don't understand. I don't want to draw my pleas in.
Oh, it's too late for that. We can discuss
Why am I
that
being
next
arrested for, man?
You're not arrested. You pled guilty to stealing $8,000
No, I pled guilty.
and then canceled your bond.
Man, it's crazy, man.
Yes, I think so.
Okay.
One of us is.
Why
All
am I
right,
being
I'll see you
arrested
next
for, man?
Tuesday.
The climax arrives decisively. After the guilty plea, the judge cancels the defendant's bond. The presumption of innocence no longer applies. The defendant appears confused, but the judge explains plainly: once guilt is admitted, the legal landscape changes. It's a firm, controlled ending that underscores accountability. Justice here is measured but unmistakably serious. If you found this breakdown valuable, make sure to like the video, subscribe to the channel, and we'll see you in the next video.